Welcome back. Thank you for being with us here at the weekly webinar. I'm Kristen Smith. As it says here, I'm a member in our Syracuse office, and I am in the labor department. And I'm here to guide you through this week's webinar again. So I want to tell you, before we get to the lineup, I want to remind everyone that we are in the midst of our annual Labor, Employment, and HR conference throughout a number of cities in the state. Just later this week, we will be in Syracuse presenting. I will be there as one of the presenters, as well as a number of my colleagues, and then you'll see our other cities listed. So please go ahead, and if you're interested, go and sign up at bsk.com. And with that, let me get to the agenda for today. We have another great lineup for you, starting with Andy Bobrecht. Those who have been listening to this webinar since it started know Andy well, back from his days being a regular host here, who will be talking about the role of SALTs in workplace organizing, something that maybe not everyone even knows what that is. And then we'll have Stephen Sharkey from our Buffalo office, Claire Bopp from Rochester. We're going to move along the thruway and then come back to Syracuse for Brody Smith to finish things off on a real property taxation topic, which is very timely at this time of year. So going back to Andy, why don't you go right ahead with your presentation? Thanks for being here.
My pleasure, Kristen. Good to be with you. Good to be with everyone on today's program. It's been a little while, so great to be back. One issue, and Kristen and I had some discussions offline on this issue of SALTs, and she thought it would be of interest to the audience to talk a little bit about it. Certainly is interesting to me, a full-fledged labor law nerd here, and it's a what I would say a long-standing issue, but one that's taken on a new relevance of late. Just to set the table a little bit on the next slide, why don't we talk a little bit about what's been going on at the board? As those of you who have attended my programs where I talk about traditional labor law in the private sector, which entails a significant part of my practice, it's a political body, right? And it's ultimately driven by whatever political party is in charge of the White House. Of course, now that's President Biden. And as you may expect, there are a majority of appointees of President Biden in control of the National Labor Relations Board. They are individuals who are very much pro-employee and pro-labor. Here you see the picture on top of Jennifer Abruzzo, who is the general counsel, again, very much a ardent supporter of employees and union rights, and is working expressly and unabashedly to expand the scope and protections afforded to individuals under the National Labor Relations Act. Also, we have the three Democrat appointees right now on the board: Gwen Wilcox, the chair in the middle, Lauren McFadden, and David Prouty. All of these individuals have extensive backgrounds in labor. Gwen Wilcox and Dave Prouty both were labor attorneys who practiced in the private sector. Prouty worked with SEIU 32BJ. Gwen Wilcox worked with SEIU 1199, and both had leadership roles in prior unions as well. Gwen Wilcox most recently serving as a partner at the Levy-Ratner firm, a well-known labor union law firm in New York City and elsewhere. Chairman McFadden was more political in nature. Her experience was as a Senate aide, I believe, to Tom Harkin at some point, and then worked on the chief committee in the Senate as counsel there. So again, my point here, you have a lot of background and a lot of pro-union leadership that ultimately drives decision-making. And as a corollary to that, what we've seen are significant upticks in the number of unfair labor practice filings in the fiscal year 2022 that continues to increase. Election petitions in the last fiscal year were up 50% over the prior year, and we can continue to see that trend. And an election petition is where a union or group of individuals files a petition with the National Labor Relations Board and says, hey, we want to be represented by this union, and we want an election to be held. We also see increasing budgets being provided to agencies of this type. The National Labor Relations Board is no exception. It has regional offices across the United States who investigate unfair labor practice charges, and who also process election petitions, again, where those groups of employees come together and say, we'd like to have a union at this private sector employer. I think another important fact to talk about is that there is really widespread, I'd say, general support for labor unions. Polling data that I last looked at from Gallup, a well-known, well-regarded polling outfit, had that support as high as 70%. Again, that's interesting when you think about otherwise the fracture that we have politically, and really the tribalism in so many ways otherwise, but that really transcends those typical boundaries there. I put but there too at the end. We see this widespread support, but frankly, those public sentiments aren't translating into trends with unionization in the private sector. To go back and just benchmark this, you'll see on the next slide some statistics from really the origination of the National Labor Relations Act, and labor organization hit its peak in the mid-1950s at about 34% of private sector employers. And again, there we were a heavy manufacturing industry. You had car manufacturing plants across the United States, steel manufacturing, and that's where you saw a real pervasive impact with the unions and representation. Now, fast forward to the present day, that number has continued to decline. As you'll see on the next slide, it stands right now from the peak of 34% to just 6% of 6% of private sector employees are represented by a union currently. And again, despite the efforts of the National Labor Relations Board, in a majority like the current one, who's seeking to expand unionization, make it easier for employees to unionize, make it harder for management to remain union free, we still see this trend continue. The number even went down from 21 to 22. I think 21, it was just above 6%. And where you see the unions most prevalent right now in the private sector is certainly in higher education, as well as the healthcare industry. And it is very prevalent in the public sector, although that's outside the scope of the National Labor Relations Act. All right, so what does this mean, right? We see these declining trends. The unions, as I see, they're desperate. They are, and we'll talk a little bit about what SALTs are on the next slide, but the thing to remember is that unions themselves are businesses, right? They are in business, and the lifeblood of their business is dues, right? These are dues that they collect from members. That those dues constitute the revenue that allow the unions to engage in their various activities. And some of those activities include politically supporting candidates for office. And you can't forget about that element when it comes to unionization and how these dynamics work, because at the end of the day, right, the dues are collected from dues-paying members in these unions. Those dues then translate into political support for candidates who then are deciding the various laws and interpretations that we have with respect to federal labor law. So that circle continues, and there's a vested interest on the part of regulators and our elected officials who benefit from that kind of support to foster that environment. And I think unions are becoming increasingly desperate because of these trends, because they need those dues. They need more members to pay more dues, or else they can't survive. And one tactic that we're seeing an increased prevalence of is the use of SALTs right now. And what a SALT is at its core is somebody who is essentially a paid professional or paid to hire to go in, apply for a job at a non-union employer with the intent of infiltrating that job and organizing the workers in that location. And this is really something that stems from the era of big labor, but now we're seeing it used increasingly by more modern and present day labor union organizers. Again, the goal here is to gather information surreptitiously, most often, as well as to then potentially sow seeds of discontent among the employees, and then coalesce support for the union on this. And again, the ultimate goal, right, is to organize the workplace, have an election held, and then secure more dues. In the process, too, you'll also see that there will be attempts on the salts and the organizers to try to trap the employer into committing unfair labor practices. Now, with that said, as I alluded to, this is a kind of a big labor practice that perhaps to a certain extent had gone out of fashion some years ago, but we've seen in some of the more noteworthy campaigns that we'll talk about on the next page, this prevalence increasing. And without a doubt, it's making a comeback. I'll tell you, I see it in the course of my practice in again, much smaller scale than some of the things we'll talk about here with Amazon and Chipotle and Starbucks, but I see it in the course of my practice where these salts are being used. Again, somebody is being paid by a union to go into that non-union private sector workforce with the express intent of organizing those workers. The tactic and I think the rationale behind it is a little bit different these days than we've seen in the past. And I think it's worth mentioning, right? I put the topic on there, workers' rights. Now, that's something that we would hear about, right? The union is going to advance workers' rights. And once upon a time, I think that meant, hey, better pay, better benefits, more days off, more protections at work. And I think that was the intent behind it. But if you really peel back the layers of what that term means, it has its origins in principles of socialism and communism. And that's really the tactic that we see. It's more of a philosophy. Some will call it a cult almost, where this groupthink is identified and there's the support coalesces, not so much around, hey, unions are good and you need a union and here's what they can bring for you, but rather there's a philosophy to this. There's an ideology that we want you to attach yourself to now. And that's what's taken place at Starbucks, at Amazon. Those of you may be familiar with the Staten Island warehouse that was the first to be organized in Amazon. The two key individuals who led that, among others, were salts, right? Chris Smalls, you see his picture there with his hat on backwards and his sunglasses on. One of the more famous organizers here was an employee salt there. The other, Justine Medina, who's front and center with the glasses on and the red shirt and smiling. Justine is actually was also an employee salt there, but driven philosophically to get involved in this. Justine Medina is on the executive committee of the New York State Communist Party, for your frame of reference. And we're also seeing in these higher profile instances, you have people who are really, their education and experience exceeds what's required for a particular position, but they're going in there with this intent. Jazz Brizak was the individual in SALT who was influential in the Starbucks campaign. Jazz is a Rhodes Scholar, very bright individual, very well educated, and went and applied for a job as a barista at Starbucks and was influential in organizing their very first store. And of course, that's cascaded into a number of issues now. All right, so I just want to ask a couple quick questions, and Kristen, I apologize for going over just a little bit here, but these are questions that, first a point, and then some questions that I want you to think about. First, I remember when I started as a labor attorney, I heard of this concept of salts, and I thought, this can't be real. Can this really happen? This seems disingenuous. It seems like it's full of fraud. Is this really a tactic that is lawful? And I can tell you, if done properly, the answer is yes. And I think the takeaway for you to be mindful of is that it is unlawful under the National Labor Relations Act to discriminate against assault based on their union activity. Now, there's a lot to unpackage potentially there, but I think that principle is important for you to keep in mind. Now, I also want to ask you a couple questions, and these aren't questions that are appropriately answered on a program like this, but rather I think are good questions for you to ask your labor attorney who you work with, or if you have concerns about labor organizing or assaults in the workplace. First, what would you do if an applicant interviewed and showed up either virtually or in person wearing a union shirt and a hat? This can and does happen. And this is more of an overt type of assault, but this does happen. What would you do in that situation? How would you react? And keep in mind, your reaction can have a drastic and dramatic impact as to what happens from that point with respect to an organizing campaign and proceedings before the National Labor Relations Board. And further, what if that same, as you'll see on the next slide, what if that same candidate says, hey, oh, by the way, I see you have many vacancies. I am generally interested in applying for one of those vacancies and working for you. But while I'm here, I also intend to create a labor union at your shop. How would you react to that situation? What would you say? What would you say? Again, here, the stakes can be very high, and I think it's important for you to consider those points. All right, as I wrap up here, I just did want to give you a few takeaways on the next slide. I won't go through them exhaustively, but these are some things I think that are general important principles, both with respect to if your objective is to keep your business or organization union free, as well as to, I think, hedge against the potential influence and impact of salting. But common sense things for the most part, but let's be fair, let's be reasonable. Let's express kindness and support to our employees. Let's make sure they have agency, and let's make sure they have outlets of communication with us, right? That's, I think, perhaps the most important thing. We need to be engaged with our employees, and they need to have the ability to communicate with us about concerns. And don't forget, this isn't today just about unions bad, company good, unions good, company bad necessarily. There is a philosophical, ideological element to this now, and you have to take that into consideration if your intention is to remain union free. Kristen, sorry for running over there a little bit. I apologize.
It's okay. Interesting stuff, Andy. Thank you so much for being here today and sharing this information with us.
Sure,
and
my pleasure.
Yeah, any questions? At the end of this presentation, there'll be a slide that has everyone's contact information.
Great. Thanks. Take
All
care.
right.
Good to see everybody.
So we're gonna move on to the next topic. I mentioned that we have Stephen Sharkey here from our Buffalo office. He's a litigator. He wrote an article that we have on our website probably about a month ago about employer counterclaims. And so thought that would be an interesting topic for us here today. So go right ahead. Thank you for being here.
Thanks, Kristen, and good afternoon, everyone. Pleasure to be here today. Talking to you today a little bit about the intersection of employer counterclaims and retaliation. This is prompted largely by, there was a very recent Second Circuit decision in the case of Kim versus Lee. And I'm going to talk a little bit today about that case and how that impacts employer counterclaims and whether it amounts to retaliation. The first sort of fundamental question is, do counterclaims against an employee amount to retaliation? And you may say to yourself, why is this important? Why is this something that should concern me? I could tell you, as a litigator, it's a very common dilemma faced by my employer clients when facing lawsuits commenced against them by somebody asserting claims of discrimination, and maybe they themselves engaged in some misconduct, and the employer is considering filing counterclaims against them. And they want advice on whether or not to do so amounts to retaliation. And historically, this has been a very gray area of law. The question I frequently encounter and get asked by my clients is, can otherwise legitimate counterclaims against that employee be construed to be unlawful retaliation? And the short answer is, it's not entirely clear, and potentially yes. And because of that, what I often see is that the fear of being subjected to a retaliation claim often deters employers from bringing these counterclaims against the employee who has filed a suit against them. And recently, there was a decision in Kim versus Lee by the Second Circuit back in early March, just a couple months ago, which shed some light and touched on this issue. And some of the facts and background of Kim versus Lee. Mr. Kim was an employee who worked for the Korean Central Daily News. He sued his employer for failing to pay him overtime in violation of the Fair Labor Standards Act and New York labor law. During the course of the litigation, his employer's attorney, during a deposition, asked him some quote unquote threatening questions about his retention of copies of certain work related documents following his employment. After the deposition, based on that testimony, the defendant amended its answer to assert counterclaims against Mr. Lee for breach of a confidentiality agreement that he had and for conversion because of his theft of some of these documents. Now, Mr. Kim maintained that these counterclaims were frivolous. And so what did he do? He filed a separate lawsuit against not only the employer, but its outside attorney, claiming that he was retaliated against based on that conduct. And the district court dismissed his retaliation claims, concluding that they were not objectively baseless. Mr. Kim then appealed that ruling to the Second Circuit, claiming that they were retaliatory and baseless. So what did the court rule in response to Mr. Lee's appeal? Well, they ultimately disagreed with Mr. Kim and affirmed the ruling. The reasoning of why they did was interesting. And what they did is they looked at what a plaintiff must show to establish retaliation under the FLSA. And that's participation in a protected activity known to the defendant, an employment action disadvantaging the plaintiff, and a causal connection between the protected activity and the adverse employment action. And what the court said is Mr. Kim had undoubtedly satisfied the first prong, but the contested issue was whether he had sufficiently alleged an employment action which disadvantaged him. So the court ultimately concluded that the counterclaims did not satisfy this prong, and held that Kim had failed to allege sufficient facts to support his claim that the counterclaims filed against him constituted actionable adverse conduct. And the court looked a little bit at the FLSA, and it stated that in an employment action disadvantages a plaintiff, it might well have dissuaded a reasonable worker from making or supporting similar charges. And then the court also noted, and this is where the ruling gets interesting, it said that district courts in the Second Circuit have held that baseless claims or lawsuits designed to deter claimants from seeking legal redress constitute impermissible adverse retaliatory actions, even though they do not arise strictly in an employment context. So they said, okay, we know that baseless claims or lawsuits are retaliation. So what they did is they looked at whether or not these counterclaims were baseless. And it's a very difficult standard to meet for an employee if that is the standard. To be baseless, a counterclaim must, quote, have no basis in fact or sound reason, and a claim is frivolous if it's based on an inarguable legal conclusion or a fanciful factual allegation. So the court then examined defendants' counterclaims to determine whether they met this standard, and ultimately concluded that the plaintiff had failed to plausibly allege that the factual allegations in the challenge counterclaims were frivolous. And as I mentioned earlier, the two claims he asserted were breach of contract and conversion. With regard to the breach of contract claim, the court noted that Mr. Kim admitted that he had a confidentiality agreement in place, and he didn't dispute that he had taken certain documents, that the documents were deemed confidential, and that he did not have permission for those. And likewise, the conversion claim, Mr. Lee argued, well, merely taking electronic documents does not amount to conversion under New York law. And the court ultimately said, at a minimum, this was a non-frivolous argument for extending, modifying, or reversing existing law. So it rejected his arguments on the counterclaims. It likewise rejected his arguments on the deposition questioning, saying that they too did not amount to actionable adverse action, as they were within the scope of permissible discovery and were potentially germane to his credibility and conduct during his employment. So the questions that come out of that are, what are the implications of Lee versus Kim? First, more importantly, is there a distinction between claims asserted under the FLSA and the New York labor law? And in that regard, I note that the court's decision and analysis was focused solely on retaliation under the FLSA. It did note, however, in a footnote, that the parties treat the analysis under the New York labor law as coextensive with its analysis under the FLSA, and have not independently briefed any arguments under the New York labor law. They did say, we accordingly assume without deciding that our disposition of the retaliation claims under the FLSA is dispositive of the New York labor law claims as well. So you may get creative employment lawyers arguing that this ruling does not apply to claims under the labor law, but the analysis seems to apply equally to both. The bigger issue is, does this ruling extend to non-frivolous counterclaims or claims against an employee who is engaged in protected activity? The court held that baseless and or frivolous counterclaims are retaliation, but was the inverse necessarily true? That is, are non-frivolous counterclaims not retaliatory? In other words, if I have a legitimate counterclaim that I have against an employee that has sued me in a discrimination claim, can I assert with confidence that counterclaim against them, and it will not be deemed retaliation? Unfortunately, the ruling of Kim versus Lee did not extend that far. The Second Circuit expressly noted in another footnote that the parties did not submit any arguments whether a non-frivolous counterclaim could constitute retaliation. And the court expressly did not decide whether and under what circumstances a non-frivolous counterclaim may constitute unlawful retaliation. So the question is still up for debate, and impliedly, based on the court's decision, there certainly are circumstances in which even a non-frivolous counterclaim could potentially still amount to retaliation. And there's a case actually that I've cited here, this Nunez versus Metro Learning Institute from just 2021, where the court expressly noted that issue is still an open question in the Second Circuit. So while this decision does provide good guidance, some guidance to the employers on this point, we think careful consideration still needs to be made, taking into account many different factors before asserting any counterclaim or claim against an employee who has sued their employer to avoid a retaliation claim. And some of the things you have to look at, of course, are the nature and timing of the counterclaims at issue. For example, let's say I've got an employment agreement with an employee, and I've known for many years that employee is not complying with certain terms of that agreement, but I've never done anything about it. Then years later, after that employee sues me for discrimination, if I were to turn around and suddenly decide to assert a counterclaim against him based on his breach of the terms of that agreement, it looks bad. And it also suggests that you're only suing him because he sued you, which may give rise to a claim of retaliation. So I think it's a delicate dance, and it's something that you need to examine on a sort of case and fact specific basis. But there is certainly some room there to assert it. And I certainly do not discourage employers from doing that merely because a lawsuit or claims have been asserted against them. And that is all I have today on Kim versus Lee. So thank you all very much for your time.
Thank you very much. I really appreciate it. And, I think as a labor and employment attorney, the word retaliation is always on our mind with every decision and many interactions with employees. So this is another interesting angle when it comes to the litigation context. So thank you very much. So we have another litigator up here today with us to talk about an issue that might arise with employee handbooks. And I know we spend a lot of time here in our practice working with our clients on employee handbook issues. So interested to hear what you have to share today, Claire. Thank you.
Thank you for that introduction, Kristen. And it is a pleasure being here speaking with all of you today. As Kristen mentioned, my topic for discussion today is breach of implied contract for wrongful discharge based on provisions in an employee handbook. So you may be thinking to yourself, generally handbooks aren't what we would consider an employment agreement, which is true. But that being said, there is a narrow exception to the at-will doctrine that's been recognized by the Court of Appeals, which has been dubbed the handbook exception, based upon a 1982 Court of Appeals case, Weiner versus McGraw-Hill. And in that case, the Court of Appeals recognized that there is a cause of action for breach of an implied contract of employment arising from written promises contained in an employee handbook, as well as the employer's oral assurances at the time of the hiring, to the effect that it was the company policy not to discharge employees other than for just cause. And the Weiner court held that in that instance, the individual former employee held a claim against the former employer for discharge without just and sufficient cause based upon that implied contract of employment. That case was pretty specific. In that case, the employee had put forth allegations that he had forfeited other job opportunities in reliance on the employer's assurances not to discharge him other than for just cause. And the Court of Appeals held that that detrimental reliance on the part of the employee was sufficient to state a cause of action for breach of an implied contract that was created by virtue of these oral assurances and the employee handbook. Now, since 1982, when the Court of Appeals rendered its decision in Weiner, that has been whittled down some, and the holding in Weiner is limited and it's pretty fact specific. And because of that, courts have held that breach of an implied contract actions don't lie where the employee manual provided only general policy statements and supervisory guidelines and did not otherwise contain any specifics as to jobs or positions, salary, or terms of employment. There was no allegation of any specific period of employment or of any express or implied promise that the employment would continue for an indefinite period of time, or in instances where the employee could not have relied on the promise in accepting this job and giving up another job. So given that, the courts are uniform, that they're hesitant to transform routinely issued employee manuals into a binding contract. But that being said, it is important to keep in mind that these policies that are contained in your handbook can form a basis for a breach of an implied contract under certain circumstances. So just to kind of recap what an employee would need to show in order to state a viable cause of action for breach of an implied contract based on provisions of an employee handbook would be: one, that an express written policy limiting the employer's right of discharge exists; two, that the employer or one of its agents made the employee aware of this policy; and three, that the employee detrimentally relied on the policy in accepting or choosing to continue employment with that employer. So those are all important things to keep in mind. And in addition, when you're drafting or working with your attorneys to help you draft your employee handbooks, the courts in New York have also held that if there is a legal disclaimer at the outset or contained in your employee handbook that says that nothing in the manual is intended to create a contract or otherwise create any type of contractual relationship between the employee and employer, that in that instances, if a disclaimer exists, the employee cannot bring a breach of implied contract based on the manual policy or statement. So it is extremely important to include those legal disclaimers in your handbook and to be mindful of, the drafting of your handbook, the promises or assurances, even if they're verbal, that are made to your employees upon hiring, because as noted, although the Weiner decision is narrowly applied and is very fact specific, New York has recognized this kind of exception to the at-will doctrine of employment based on this handbook exception. So it's just an important thing to keep in mind. And that's all I have on this topic, unless there's any questions.
Great, thank you, Claire, so much. And I think we experience. I work on handbooks a lot, right? And I'm always adding in that legal language, and sometimes it feels a little out of step with the the sort of the tone of the handbook that, the employer might want to be much more welcoming and positive and upbeat. But, we see from these cases why we do, always recommend that we add in this disclaimer type language. So it's good to have that context of where that comes from. So thank you.
Yep, absolutely.
All right. So moving on to our final topic, we are going to switch gears off of these labor type topics that I often veer towards just because of my practice, but I wanted to have Brody on tonight, or it's not evening yet, this afternoon, to talk about real property taxation. He recently did a presentation internally at the firm, which was really helpful, and thought he could share some of those thoughts with our guests here. Thank you.
Thanks, Kristen. So with the last 7-8 minutes or so here, let me give you some reminders. This time of year is when real property taxes are set. So a lot of clients end up having questions about that process, about deadlines. And I think it's important for attorneys in all areas to be able to at least direct them to the right information, or if they decide they have an issue where they want to seek some more help, just so that you have a sense of when these decisions are made, when the deadlines are to challenge certain assessments, both administratively and judicially. And this will be your primer on the tax calendar. So real property taxes in the state of New York are governed by the real property tax law. And Article 3 of the real property tax law fixes the calendar for the state. These dates that I'm going to go through with you briefly here apply to just about every community in the state uniformly. There are a few exceptions. If you're in a city like the city of Syracuse, Buffalo, Rochester, sometimes the city charter will vary these dates, and they may all be pushed back a few months. So that's worth checking into if the client's property is located within the city limits of one of those cities. So first of all, there's the valuation date. The valuation date is July 1st of last year. And the reason that we have to pick a valuation date when valuing real property is market conditions change. The world changes constantly. And so there needs to be a snapshot date in order to value property. So property sales occur throughout the year. Market information is always changing. Market values are always changing. So the date that we pick to value a piece of property is July 1st of last year. Now that's different than the taxable status date. The taxable status date is March 1, so 2 months ago. What the taxable status date is the day when they actually look at the inventory, which is present on the property at that moment in time. So construction happens all the time. Properties are constantly changing. Outbuildings may be built. Old structures may be demolished. Renovations may occur. March 1 is the snapshot date when you actually look at the inventory of what's present on the property, and that is the taxable status date. So the condition and ownership on that date is critical. Now, the other part of that is ownership, right? And this comes up often, I think, particularly for our clients at Bond, is the ownership sometimes is university, sometimes is not-for-profit, school district. Well, the taxable status date is also your deadline for submitting exemption applications. So you have a client who's acquiring property or selling property. That is the key date that, let's say, it's an office building. It was previously used by a private business, but now it's being purchased by a not-for-profit. It's then going to put it to a not-for-profit use. The taxable status date is March 1st. That's the key date. If they close after March 1st, the most likely outcome is they're going to remain on the rolls. So you're going to want to make sure that that's contemplated in the closing documents if that's an issue for this not-for-profit that's not used to paying real property taxes. What then happens after that is, the assessor gets all their exemption applications. They prepare a tentative roll. That tentative roll is published on May 1st. So that tentative roll includes a lot of information about all the property in the town or the village or whatever. But it also includes the proposed assessment for each property, listing both the name of the owner and the tax parcel number, the amount of value that's attributed to land versus structures, and a lot of other information. That tentative roll on May 1 begins the clock if your client wants to challenge their real property taxes. They've got a few different options, but the deadline is the fourth Tuesday in May. So this month, the fourth Tuesday in May is the drop dead deadline to administratively challenge the assessment of real property. So what happens between May 1st and grievance day, which is the fourth Tuesday in May? You have an opportunity to go to the assessor and negotiate a stipulated new value for property. You can submit a written grievance and then appear in front of an administrative board appointed by that municipality called the Board of Assessment Review on the fourth Tuesday and plead your case as to why the amount on the tentative roll should be changed. And then once that board rules either in your favor or against, the final roll is then produced and must be completed by the assessor by July 1st. Now, there's an area there during the month of June where corrections can be made, but that's not the same as a challenge evaluation based on just a different opinion as to value. Those corrections are administrative errors that occur that can be corrected. Once that July 1 date comes out, you get your final roll, and that's the decision of the municipality as to the assessment of that property. You then have 30 days to file a lawsuit if the client desires to challenge that judicially. Real Property Tax Law Article 7, it provides the procedure for a challenge in court. The other wrinkle, if you're dealing with, particularly client contacts who are asking you for advice for their own personal property, perhaps, there's also a SCAR proceeding that's available as an alternative, SCAR standing for Small Claim Assessment Review, and that can be used for single family homes. If somebody wants to challenge their assessment on the final roll following July 1st, and again, they have to have filed a grievance and exhausted those administrative remedies, they can do a small claims assessment review proceeding, which doesn't necessarily require an attorney or an appraisal, though it's better if you have an appraisal. And it allows you to go in the same sort of procedural posture as a small claims lawsuit, go appear before a hearing officer without worrying about the rules of evidence and that sort of thing. And you can challenge the valuation of your home. So I see it is 12:45. I will stop there, but if anybody has any questions about these real property tax assessment topics or anything else, please don't hesitate to give me a ring, and I'd be happy to answer your questions and point you in the right direction.
Thank you very much, Brody, for that overview. And like you said, if anyone has any questions about that area, certainly reach out to Brody. And then if you could, thank you, Kathy. On this slide here, we have all of our presenters from today who would be more than happy to address any questions that you have about their topics. So thank you all for coming to the webinar week after week. Thanks for being here this week. And we look forward to seeing you next week and the week after. Thank you so much.